Hello and welcome to this talk about health and safety dismissals and detriment. My name is Declan O'Dempsey. I'm a barrister at Cloisters Chambers. If the reason or principal reason for your dismissal is health and safety and you're an employee, you may be able to claim that the dismissal is automatically unfair. This right applies from day one of your employment and compensation is uncapped. If you're a worker, you can also argue that this right applies to you due to the European Health and Safety Directive, which is Directive 89391. Article 3 refers to the concept of worker, and it's given a broader meaning than the concept is given under UK law. There's also a case that deals with this from the European Court called Fennell and Centre d'aide par travail La Juvaine, C316 of 2013. You should refer the tribunal or your employer to these materials. In any event, the termination of a worker's contract is a type of detriment, and there are separate rights of the Employment Rights Act that deal with claims which are appropriate where you're a worker and you're subjected to a detriment because of the health and safety matters I'm about to go over with you. I want to look at unfair dismissals in the context of health and safety first and in a bit more detail. Section 100 of the Employment Rights Act provides that a dismissal is automatically unfair if the reason for it is one of the following. You're designated by your employer to carry out activities in connection with or preventing or reducing risks to health and safety at work, and you carried out or you propose to carry out any of those activities. Under Section 100, subsection 1A, you're protected against dismissal if that's the principal or only reason for the dismissal. Under Section 100, subsection 1BA, you're protected for taking part in the election of health and safety representatives as well. The second scenario I want to look at is under Section 100, subsection 1B, and that's an automatic unfair dismissal where you're a health and safety representative or committee member and you're dismissed, and the reason for it, or the principal reason, is that you were performing functions as a health and safety representative or as a committee member, or you were proposing to do so. Let's think next about the situation where at your workplace there's no safety rep or committee, or where it's not reasonably practicable to raise the matters that you eventually do raise via those systems. Now, if the reason you're dismissed, or the principal reason, is that you brought to your employer's attention or proposed to do so certain circumstances, then the dismissal will be automatically unfair. Those circumstances are the ones which are connected to your work and which you reasonably believed were harmful to health and safety. That health and safety can be someone else's health and safety. It doesn't have to be your health and safety. It doesn't have to be the health and safety of the employer's workforce either. But you have to use reasonable means to bring the circumstances to your employer's attention. Now, if you do all that and you get dismissed anyway, you should be able to claim unfair dismissal, which will be an automatic unfair dismissal under Section 100, subsection 1C. Section 100, subsection 1D deals with unfair dismissals in certain circumstances of imminent danger or risk to health. Those circumstances are circumstances of danger, and you must have a reasonable belief that they're serious and imminent. There must be circumstances which you could not reasonably have been expected to avert. The dismissal is going to be unfair if you left or proposed to leave, or while the danger persisted, refused to return to your place of work or any dangerous part of it. If you get dismissed because of those reasons, the dismissal will be automatically unfair. That's the impact of section 100, subsection 1D. Finally, your dismissal will be unfair if the reason for it was that you took or proposed to take appropriate steps to protect yourself or other persons from the danger. The Act doesn't say what those steps are permitted to be, other than saying that they must be appropriate. But the Act does say how the tribunal will look at the question of whether the steps are appropriate. The tribunal will look at all the circumstances, and these are to include in particular your knowledge and the facilities and advice which were available to you at the time. The dismissal will be unfair under section 100, subsection 1E, if the reason for it was that you did remove yourself in those circumstances. However, if your employer proves that the steps you took, or the ones you proposed to take, were so negligent for you to take that a reasonable employer might have dismissed you for taking them or for proposing to take them, well then the dismissal will not be an unfair dismissal. On the face of it, a person who refuses to come to a workplace which is highly infectious because they live with a vulnerable person might be taking such steps. However, I'd urge you to take considerable caution before going down that particular line if the virus is on the wane at the time that you decide to take that action.